I am Angela Foster, better known as Angie Foster, and probably will be called Angie throughout this webinar, as well as some other people who have names that we will tell you who their name is and who they probably will be referred to. But before I introduce the panel and a little bit more myself, I wanted to thank our sponsors and co-sponsor. This is being sponsored by the Silicon Valley Arbitration and Mediation Center. The Silicon Valley Arbitration Center is a leading tech. It works with technology companies, law firms, and AER institutions and universities around the globe to provide educational programming and related resources relating to effective and efficient resolution of technology-related disputes. Our co-sponsors are the College of Commercial Arbitrators. The college is comprised of nationally and internationally recognized commercial arbitrators that promote the highest standards of integrity and professional practice in the field of commercial arbitration. Shavitz Lindsay is a law firm located in New York. It practices in many groups, but specifically for our purpose today, two of their groups are domestic, international, commercial, litigation, construction, and arbitration. Again, I want to thank our sponsors and co-sponsors. I am Angela Foster. I'm a member of the Silicon Valley Arbitration Mediation Center. I'm also on the tech list. I'm also on the executive board as a treasurer. And I am an arbitrator, mediator, and attorney, and my specialty is technology. Now, I'm going to go in alphabetical order with the panelists, not for any other reason than the fact it's alphabetical order. Simon Bomey is vice president of a company called Leaguer, which he will probably talk about a little bit later. He works at the intersection of dispute resolution and legal innovation. He's a tech entrepreneur and mediator, and he's founded and advised multiple legal companies along with writing and teaching online dispute resolutions for the past 10 years. Our other panelist is Mary Ann Parinelli. Mary Ann is located in the Boston area, and I forgot to mention that Simon is speaking to us from California. But I'm mentioning Mary Ann because Mary Ann's area had a windstorm last night, and a lot of trees fell down, and she's had some electrical problem, which is loss of power. Therefore, you probably cannot see her, but you will hear her because she doesn't have any power. She couldn't log in like the rest of us. Mary Ann is independent arbitrator, mediator, and consultant. She practices in Boston as in New York City. She focuses on complex commercial and intellectual property disputes. And she's also a member of the Silicon Valley Technology list. The next speaker is Andrew Poplinger. Sorry, Drew, if I'm messing up your name. And he will probably be referred to as Drew. He's a partner with Shavitz Lindsay, located in New York, as I mentioned earlier. What I wanted to also mention, and I forgot to say it as I was going along, the hope with this program is to give you perspectives from different areas. Simon is going to bring the perspective from the platform. He's also going to talk about mediation, which he does a lot of mediation online. Mary Ann is an arbitrator, as I mentioned earlier. She's going to talk about arbitrating complex cases and what we've learned. Drew is an attorney, and he does a lot of arbitration as well, specifically in construction area, and he's going to bring the advocate perspective to this panel. Our next panelist is Richard Silverberg. Rich, AKA Rich. He's also the past president of the College of Commercial Arbitration. He has a ton of experience. He's been a partner with Dorsey Whitney for, I don't want to date you, Rich, but it goes back to 1988. Folks can do the math. He's on a lot of panels, and he's been noted as the best lawyer of America for arbitration and mediation since 2006. All right, thank you, everybody. And I think at this point, we're probably ready to start. Okay. The first thing I think we need to do, I understand there's almost 50 people who have registered, and hopefully all of you have as well logged in. But to help the panelists out, what we wanted to do is a couple things. One, there should be a queue on your Zoom pad that says Q&A. So we're going to try to accept questions as we go. And so if you want to present a question, put it in the Q&A, not in the chat. And we will be periodically checking the Q&A, and probably we'll try to answer those questions as we're going. The second thing that we want to do, and it goes back to what I said before, this prompted this particular webinar was predicated on what has happened in our country in terms of the pandemic and how it's putting people in isolation, but yet in the dispute resolution community, we've managed to continue. And we continue by doing virtual arbitration and mediations. And since this has started back in March, and we're now in October, which is like 6 months later, and we're still talking about this, we wanted to put together some concepts of what we saw happening during the time and what kind of lessons we learned from mistakes and blips that went along the way with doing virtual arbitration mediations. Now, to get that going, the first thing I'd like to do is put up a poll, and it's going to give us a sense of who is attending right now. Now, there are 3 questions that you should see, and you can answer all that apply. The first question is select all of the following that apply to you, which is a multiple choice, and it's basically designed to ask who you are: arbitrator, mediator, advocate, or none of the above. And if you represent all, of course you can't be none of the above and all, but if you represent an arbitrator, mediator, and advocate, please check all 3. The second question is, have you mediated virtually? So we want to get a sense of, again, who has done any virtual mediations or not. And the third question is, have you arbitrated virtually? Again, yes or no answer. All right. So we're going to have Bill, who is the man behind the curtain that you cannot see. He's going to be tallying this up, and momentarily we'll get a sense of who we have. Just to give you heads up, there will be another poll for a totally different type of question later on, so stay tuned. All right, looks like our results have come in, and everybody should be able to see it, including the panelists. Hi, Marianne is there. I thought you were only on the phone. Thank you. Okay, it looks like 50% are mediators, arbitrators, and advocates. This is interesting. I'm assuming that we have a serious mix. Very small amount of people represent none. It's only 6%, but everybody is an arbitrator, mediator, or advocate. Now, when it came to have you mediated virtually, it's 44 to 56%, so that's a nice mix. Have you arbitrated? Mine is kind of missing at the end. Let's see, I see 44% have arbitrated virtually. Okay. And it seems about the same amount of people have also mediated virtually. So that's interesting. When we were in the process of preparing for this panel, one of the questions was whether there were more virtual arbitrations than mediations, but it seems to be kind of equal. All right. Now, I'm going to start off with just a question that I'm going to throw out to the whole group, but I guess I'm going to target Rich first to deal with this. Is when we started with the virtual mediation arbitration, of course, there's a lot of kickback and a lot of issues that came about with people not wanting to do it. And I just want to set the framework for how we're going to walk through this webinar. So Rich, can you kind of give us a sense of some of the concerns that you heard early on, and we'll walk through how they either change or evolve into other types of issues.
Sure, I'd be happy to, Angie, and good afternoon, everybody. So I think the best way for me to introduce the topic that all of us are going to be talking about today is to relate a situation that I encountered toward the end of February of 2020. I was chairing a 3-arbitrator panel in a very hotly contested arbitration that was scheduled to go 2 weeks and to commence in mid-March. And toward the end of February, I called an emergency conference by telephone with all the parties and the panelists, because if you remember back to late February, things were starting to pick up in terms of potential danger. And we had some unique circumstances in our arbitration in that we had an 84-year-old panelist on the arbitration panel, and we had an 84-year-old party. And at that time, all of the attention was on folks who were of advanced age. So we called a conference and we told the parties that it was increasingly becoming likely that by March 15th, we would not be in a position to do the arbitration in person from the same physical location. And I raised the possibility of doing it virtually. And there was like dead silence on the line. Nobody really wanted to engage. And as I drew out the conversation between the parties, both of whom were represented by very highly experienced, high-powered law firms, the number of concerns and complaints about the possibility of doing it virtually was long. And I thought what I would do is just give you a brief recitation of what those were, because we're going to be talking about those in greater detail. So those of you who have done virtual arbitrations and mediations, and it sounds like we've got a pretty experienced group, will recognize these, because I'm sure that you've either heard them yourselves or you've articulated them if you've represented parties to arbitrations and mediations. So the one that was at the top of the list is that this is a very important case to me, and I don't want to do it virtually because the trier of fact is not going to have the ability to assess the credibility of witnesses in the same fashion that he or she would if the hearing were live and in person. The second in order of magnitude was that people were very squeamish about doing a confidential arbitration online because of all the privacy and security and fending off cybersecurity attacks, particularly in a case like the one that we had, in which the issues were very sensitive. Then there were concerns about the technology. Would we have the adequate connectivity? The lead lawyer for one side was decamping in the Berkshires, and he told me that he doesn't have high-speed internet, and that when he called the internet service provider to upgrade his service, the service provider would not come into his house because of the possibility of being infected by the virus. So there was that practical concern. Then there were fears about mistakes that could be made. If people were going to be using virtual rooms, suppose whomever was operating that, like an inexperienced arbitrator, might put the wrong people in the wrong places and say the wrong things at the wrong times, and that would be prejudicial. There were also concerns about witness coaching. If people were going to be in rooms by themselves, how would we know that they weren't being tutored either electronically or by somebody who was outside the scope of the camera? And there were concerns about whether somebody might be recording the hearing improperly. As you probably know, on the Zoom platform, there's virtually a default that things will be recorded unless you turn it off or you change your settings to eliminate the possibility of recording. And then there was the overall concern about witnesses not having their lawyers sitting next to them. I mean, after all, those of us who have been involved in the litigation process and thereafter the dispute resolution process in the ADR community, we know that witnesses are not comfortable testifying at all unless they're professional witnesses. And all other witnesses are generally comforted by the fact that they have their attorneys sitting next to them. Well, that wasn't going to happen in this particular situation. So the upshot of my conference was that it was a very easy result. Both sides refused to pursue virtually, and we agreed to adjourn the hearing for 2.5 months into sometime in May, by which we were certain that we would be able to go back to a live hearing. And in the interim, when it became clear that that was not happening, we encountered a problem that we are going to be talking about at greater length, which is the claimant withdrew the objection to a virtual hearing, the respondent maintained the objection, and then it was up to the arbitrators to decide whether we would honor the objection or whether we would go virtually. So Angie, I'll kick it back to you, but I think that's the prelude for some of the issues that were confronting neutrals back in February and March.
Okay. And before we talk about those issues, which were quite a bit, I want to get Drew's perspective from the client. I mean, Drew, as I mentioned earlier to the audience, that Drew is our representative as the advocate, because he was the attorney in some of these virtual matters, whereas Rich and Marianne were arbitrators, and Simon was a mediator. So I want to get a sense of what you thought some concerns were from your client's perspective.
Sure. Thanks, Angie. So, I think all of the issues that Rich mentioned are concerned to some extent or another for most clients. But setting aside the standard issues concerning technological concerns, confidentiality, I think what we've heard from some clients is certainly those who are less experienced with dispute resolution, arbitration, are concerned with not having their lawyers, having immediate access to their lawyers as an issue that Rich touched on. But also others who are more experienced and are used to having a more hands-on role are concerned that their ability to act in that capacity is diminished by the online platform, by not being in the same place as their lawyers, as the hearing's going on. They can't provide immediate feedback or get immediate reactions. They can't pass post-it notes. They can't speak, during breaks in the proceedings about what has just come and what's about to happen when the hearing resumes. So I think from that perspective, and most interestingly, because I hadn't thought about it until these concerns were expressed to me, is this notion that the virtual platform diminishes the client's ability to be involved in the prosecution of their own cases. And I think there's alternatives, obviously, that can allow for, lines of communication, emails and text messages, the virtual breakout rooms during breaks. But I think the concern we've heard is that the immediate reaction and feedback that comes from being in the same room and being next to your lawyer while they're presenting your case is absent in the virtual platform.
Okay. All right. So now we're going to walk through some of these issues that you guys just talked about. But before we walk through all of them, I think Rich kind of mentioned a little bit before about the parties not wanting it, how he delayed something for a couple months. And so I think this might be a good time to first get a sense from the audience, again, with another poll as this particular question, who should decide if the parties are against it or one party is against having a virtual, who should make that decision, or should it go virtual? So at this point, I'm going to ask Bill to put up the next two polling questions so we can kind of get this out of the way and then deal with some of these other issues. All right, so the first question of this next set is, should the arbitrator hold a virtual hearing over the objection of one of the parties? And that's a yes or no. The second question is, if the parties disagree, who should decide whether the evidentiary hearing will proceed virtually? And there are four choices. One is should the arbitrator make that decision? Should the institution that's administering it, should it ultimately go to a court? Or should the hearing just not be held virtually? Please submit your answers now. Okay, so while we're waiting for that, and we're going to get a sense of what everybody thinks, it's kind of like the elephant in the room, and then we're going to try to walk through some of these, this particular question first. I'm going to try to see what the panel did. How did they deal with it when it came up? And then we'll walk through any specific other issues before we try to tackle how each of you dealt with these problems that Rich and Drew have kind of laid out for us. Okay, the results are, all right, should the arbitrator hold a virtual hearing over the objection of one of the parties? And 74% said yes. Interesting. Only 26% said no. If the parties disagree, who should decide whether an evidentiary hearing will proceed virtually? Arbitrator, 68% said the arbitrator. 16% said that it should be kicked to the institution, and 11% said it should go to the court, and only 5% said it should not be held. Before we go forward, panel, any discussions about these type of results? What about the first one, which should the arbitrator hold the hearing over the objection of one of the parties? I know we had a pretty high number of arbitrators and mediators, but it seems that they are kind of in agreement. At least this group is. Anybody?
Rich, do you want to start since
Sure.
you actually experienced that, and then I'll share some of my thoughts on that subject?
Sure, I'd be happy to. Actually, those results are very interesting because they comport with what's actually going on in practice. I will say that there are some arbitrators that I know and who I respect who will not hold a virtual hearing if either party objects. That's just the way they feel about it. They feel that if one party feels strongly enough about it, and provided that the matter can be adjourned to a point where it's not prejudicial to the other side to delay it, that they will wait. I think most arbitrators are of a different view. And that view is that they will hear out the parties. They will invite written submissions from both parties as to why the matter should either go virtual or be delayed so it can be held in person. And the parties are encouraged to be very specific in terms of what their prejudice would be one way or the other. Claimant will normally state that he or she or it will be prejudiced because they are owed money in most cases. And they don't want to wait indefinitely for a hearing. That's why they chose arbitration. They didn't want to get all tied up in knots in court where there are extensive delays. That's why they arranged for the matter to be arbitrated in the first place. And it would defeat their independent choice of arbitration if they were compelled to wait indefinitely for an in-person hearing. On the respondent side, you'll hear lots of things, including a number of the things that I talked about earlier and that Drew talked about. So I think in practice, what's going on is that the arbitrators are making these decisions, and by and large, with few exceptions, they are going forward with virtual hearings because once they balance the factors and disabuse the parties of the notion that some of these perceived disadvantages is a game changer, they feel that the claimant is probably right, that it should go forward, particularly in a circumstance where there is no telling when an in-person hearing can go forward. Could be 6 months from now.
I have a different situation where the parties, it was again a very large arbitration and it was scheduled for March. And at the time, we couldn't go forward in March for a number of reasons, including that the hotel in which the arbitration was to take place had been closed due to COVID. So we said that we would postpone it till June, figuring that we could go forward then in person. Both of the parties wanted to go forward in person, but both of the parties agreed as everything became clear that that wasn't really an option and that they would go virtual. I think as arbitrators, when we're dealing with trying to figure this out, and I echo a lot of what Rich said, it's not dissimilar to me in ways where you have one party at the right before hearing, maybe a new piece of evidence comes up, or I had one case where there was an additional expert opinion and they want to postpone the hearing. And I think it's a question of understanding what the objections are, making sure a party is heard, making sure that you can, as a panel, to the extent, every extent possible, address the objections and try and minimize any spoken criticism. And then I think, as Rich said, submissions, and then findings that in light of what's going on in arbitration's trying goal of efficiency and economy in terms of dispute resolution, that you find that the parties have a fair and reasonable opportunity to present their case. And I don't see that forcing, so to speak, parties to go forward in a virtual hearing, given the circumstances and given the findings, would be opportunity to attack the award later on.
Okay. Do you think, this is to you and Rich, do you think that a large part of what the decision has to do with the fact, I mean, at least today, that we are still in the pandemic as opposed to making those decisions 6 months ago? Delay it versus, I've had the same thing where parties were debating about the virtual, but of course, it was early on. And now it's a little bit different that we realize we may be still doing virtual. Do you think this time, 6 months later, has changed a lot of some of the decisions that were made early on?
Well, I do. And I use my own illustration as an example, because we were foolhardy enough to think that we'd be able to have an in-person hearing by May. So there was more acceptance by arbitrators, I think, of applications to hold off on hearings until they could be done in person. But more recently, where we're being told that we're in the middle and that things could get worse yet, and we're hearing kind of anecdotal statements from providers that indicate that hearing centers may not reopen for many months yet, that in those circumstances, I think arbitrators are looking for a more compelling record before they're going to agree to hold off on a virtual hearing. And I just want to endorse something that Mary Ann just said. I think it's very, very important for arbitrators who are confronted with this kind of problem to do exactly what she said, which is to make findings, written findings, in a procedural order, which recites the fact that the submissions have been received from both sides, summarizing what the points were for and against going ahead with a virtual hearing, and then making findings on the objections so that the award is insulated from a collateral attack on the basis that a party was deprived of due process.
I also think it's useful, and I think, Angie, this was an anecdote that you shared with us, to raise a question to people who are objecting, like, what does an in-person hearing even mean these days? If you're in a ballroom and you're 6 to 10 feet apart and you're using microphones and everybody has to have a monitor to be able to see another person or see a document, you might as well be on a virtual platform.
Okay. All right, let me switch to Simon for a minute. And Simon, what issues or concerns have you experienced in the mediation world that's different from what's they've been describing, if at all, in arbitration?
Yeah, well, first, Angie, and thanks to the Silicon Valley Center for having me and to be a part of such a distinguished panel. I started in online dispute resolution just about 10 years ago, even before Zoom started, when I was doing asynchronous, more text-based resolution. And I think we'll later talk about synchronous versus asynchronous as this panel goes on. But when COVID-19 happened, it was quite bittersweet for me. I always imagine, and my passion has always been, how can we resolve disputes offline and put them online? But of course, in the middle of a pandemic with such economic hardship and people becoming sick and dying, this was not the circumstances I imagined or desired for us to get online. And within the mediation community, there was a pre-COVID, there was this hesitation to host something online because there was this idea that you couldn't understand people's facial expressions. You couldn't understand their body language. You couldn't read them. You couldn't tell if someone was telling the truth, which again, when we're talking about, witnesses and witness coaching, that is still a very important issue. But as soon as people started receiving training, and I think that's one of the core principles and the most important things that mediators and arbitrators can do is to just take a training, and I think the bar associations, all of them, need to do a tougher job of ensuring technical competency around some of this, because the technology is going to change. Zoomtopia, excuse me, which is this big conference that Zoom puts on. I was on a panel with the chief information officer of Zoom. They're going to be rolling out some changes to breakout rooms, right? Technology is not stagnant, it evolves. And so it's up to us as the leaders in conflict resolution and mediation arbitration that we always learn about it. And so when I would talk to clients, I was retained to convince people to come online. And it was essentially that there was this hesitation, and many lawyers didn't want to admit that they didn't know how to navigate Zoom. And so by providing them the tools to be successful, reassuring them that if there were mistakes made, that, you just drop out of the Zoom and I'll let you back in, reassuring people that, I'm the only one, and you and your clients are the only ones that have this Zoom password. We have a waiting room instituted. Now Zoom, the platform, has taken significant improvements in making sure that it's Zoom. So, and look at Texas, they've logged over, I believe, 700,000 hours of Zoom hearings, mediations, cases. There's a great Washington Post podcast that talks about all the great work that's going on in Texas. And, it's here to stay. And so now it's a matter of, how can we provide great arbitrators like Richard with technical assistance, so he doesn't have to worry about making a mistake, that he leaves it to his AAA case manager or his JAMS case manager, whoever it may be. And Drew feels confident that because they have the right technical expertise and the tech continues to get better, it's going to be hard for people to turn down a virtual hearing.
Okay. All right. So with that, for the audience sake, this long introduction we just did of what we're going to really talk about. So now I'm going to try to focus the panel on some of the experiences that he had that dealt with some of the issues that we just kind of described. Now, and on the panel, we have people who've had arbitrations that involve 40 plus persons. I know Simon is one of them with the mediations, that they're all online at the same time, and how they had to manage it. The same thing with Drew. As an advocate, he had cases where complex construction cases that had over 40 people at one time that are basically being viewed virtually. So before we get into some of the nuts and bolts of what happened, or the nitty gritty, so to speak, are there any things that either of you did that was pre-hearing? And this is going to be, I'm trying to get from the arbitrator's perspective, Marianne and Rich, and then I'm going to flip it to Drew. To what did you do for purposes of arbitration right now?
Okay. So before we had the hearing, there were a number of things that we went through. And in my case, I was fortunate in that the parties had agreed. So they came up with a joint order that appeared to be primarily based on the AAA order with respect to conducting virtual hearings. And I thought that was, very helpful and useful that they did that. Some of the technical pre-setup things were, making sure that everybody's, and Simon can speak to the technology of this, but we were all very concerned that our internet was, high speed and robust. As it turned out, one of the arbitrators had trouble plugging in with respect to audio, and it turned out later on when he replaced his computer that problem was solved. So in terms of getting ready for the hearing, I mean, there are issues with respect to monitors, because you certainly want at least one in addition to your computer screen so that you can look at documents that are being shared on screen. In our case, we had two so that we could look at documents being shared. We could have live note on another monitor, or we could access a joint repository of exhibits if we wanted to. So, you know, I don't know how much detail you want me to get into at this point, Angie, but we certainly had a test run a week before to make sure that people's equipment was good and that everything worked. And there were some kinks in that we had to work out. In addition, the counsel were instructed to have that same experience with their witnesses so that when we got to the day that we were pretty sure that all that would work out. We also, it was a very large arbitration, similar, I think, to Drew's. We had 12 witnesses. Each side had 10 attorneys or interns on, so that's 32. And then we had a number of tech people and from a tech organization. And it was very useful in a case this size not to have the arbitrators have to think about, you know, who was where and what had to be done. So this organization was responsible for putting everybody into breakout rooms and creating breakout rooms for the week. So every time there was a break, the panel went into the panel room and the parties went into the party room, and they were responsible for pulling people out. If there was an attorney eyes only document being shown or testimony being given, then they would pull witnesses out and put them into the waiting room, and also monitors. So for security purposes, it was their responsibility to make sure that only the people who were supposed to be in the hearing were in the hearing. And I think that if you've got a large case, that's really critical, because you want to be able as an arbitrator to focus on the testimony and the witnesses and don't want to be worrying about the technology. There are a lot more things we went to, but I will now defer to Richard and Drew so I can pipe in a little bit later.
Yeah, I think all of those are things that should be done. I do want to make a point that I think Mary Ann would probably concur with, and that is, in my view, the arbitrator or arbitrators should never be the host of the hearing. I mean, Simon could speak to this at great length, and I'm sure he will. But what we try to do as arbitrators, and I'm very thankful for it, is that there is a growing market of folks who are prepared to provide all the technical and technological support that's necessary to conduct one of these hearings. In the case of the hearing that I alluded to earlier, we actually had the court reporter employ a tech who was available for 2 weeks straight, essentially was on mute until we needed him to move people from room to room and to assist with document sharing and so on and so forth. So I think as soon as you decide that you're actually going to go forward in a virtual way, the first order of business is to decide who is going to be running the show. Mary Ann referred to an order, and that's absolutely critical. And she referred to an order that was modeled after one that's on the AAA website. I would encourage people to look for that. It's very prominent on the website, can't miss it. But there are others. CPR has one, JAMS has one. All of the dispute resolution providers at this point have a model order which can be tweaked. And that order is fairly detailed. It addresses a lot of technical requirements, such as the things involving high-speed internet and monitors and so on that Mary Ann alluded to, but they also have a lot of things in there that are designed to ensure fairness. So I'll just mention one as an illustration, and that is, in a case that I did recently, there were about 600 exhibits, and they were spread out among maybe 20 witnesses. And what each party did is they sent a hard copy set of those exhibits to the witness in a sealed envelope, and that envelope was to remain sealed until opened in the presence of the panel at the time that that witness began his or her testimony, so that it would mimic what would actually happen in a hearing where everybody was sitting around a conference room table, and that is that the witness would not have the opportunity to study the exhibits in advance of the examination. That's the kind of thing, and there are many more, that would be provided for in the order.
I think I could just add to that. rather than.
Before you continue, I'm sorry. We just got a question in the, and I think it seemed like it had been answered, but I just wanted everybody to kind of get a chance to see it. Somebody asked a question that says, could Mary Ann and the panelists expand on the tech providers they have used and have that mandated a current order, and council haven't yet submitted proposed tech providers, so value the information on market participants and lessons learned there. I think that what they're trying to find out is, I think you just mentioned a little bit more, Rich, about the order and where it can be found. But I think they also wanted a little bit more about the providers. So Jerome, I'll let you continue. I don't know if did you use a third-party provider?
We did not.
Okay.
We have since in other cases. The first time that this came up, we had a multi-week hearing that had commenced in early March, and then the outbreak sort of, the pandemic sort of worsened around us while we were in our bubble of our hearing room, and halfway through we had to convert to an online, to a virtual platform, and we use Zoom using one of the firm's premium accounts, and we did not have outside technical assistance. We had in-house technical assistants at both the respective firms who helped out with managing those issues. The thing I was going to say is, I think all of the specific issues that have come up, sort of Rich and Marion have covered them. But I think from a practical standpoint, I don't think you can underestimate the value of cooperation between counsel and clients and amongst the arbitrators, and working together to really address everyone's concerns, come up with a really detailed protocol that's set forth in an order that establishes really how things are going to proceed. I think a lot of times in litigation, there's a really contentious situation and no chance of cooperation on either end. But I think if, working together is the most important tool to make all of this happen. Agreeing to who the provider is going to be. If there's concerns with some provider from one side, being sensitive to that and looking for alternatives, understanding concerns over witness coaching, and we had a similar protocol with respect to witnesses where they received their exhibits in a box with colored tape, and the box had to be opened on screen at the beginning of their examination. Designating people to deal with technical issues and being sensitive to technical issues. If people experience technical issues during the process, not to use that as a tactical advantage. So I think, my sense is the big takeaway from all this is that real cooperation and professional courtesy is important to make sure that these virtual hearings are a success. And I think if everyone comes to the table with that attitude, they really can be, and they really are a great alternative to waiting, months or some other indefinite period of time to resolve things.
So Drew, let me ask you this question. What type of preparation or procedural suggestions would you provide coming from the advocate perspective? What did you do to prepare your client? I mean, we're kind of going to walk through some of these issues. You have a client who's a little upset that he's not going to be, or she's not going to be near you. And can you, specifically your client, whether it's in-house counsel or the client itself, and how you dealt with that to make them have that type of fear dissipate.
Sure.
As well, the credibility issues. What kind of preparation did you do?
Well, the big issue in terms of sort of internal communications on our side was we were dreadfully fearful of the breakout room issue that I think was discussed earlier, which is there'd be some mishap and you find yourself having confidential communications with the other side because someone pressed the wrong button. So we had our own separate Zoom room open that anyone can go to during the hearing to communicate regarding issues. We had the lawyers had an open text message conversation that substituted sort of for the post-it note. And we found other ways to be in constant communication with our clients. We had calls throughout the day during breaks and things of that nature. I just don't think there's a true substitute for being present in the same room with someone. But I think the technology today allows for many open lines of communications. And we should all just use those tools that are available to us. The other thing I mentioned, and Marianne touched upon this, is to make sure at the outset that you have the technology you need to proceed. In our case, we found that each of us as the lawyers, for example, had to have 3 screens, one for the Zoom, one for the to display the Zoom platform, one to display Live Note, and then a third because an iPad or something similar that has your own your own working documents, and then a cell phone to have the additional lines of communication we're talking about. And I think also another, just as a practical matter, when it's important to have a run through. I think someone's mentioned that, but a full run through with all the people you anticipate having on during the course of the proceeding on at the same time, and from the locations and using the devices that they intend to use during the proceeding, so that you don't go to a run through in your office and you think the connection's fine, and then you plan to conduct a hearing from home and find out that your connection isn't working, or that you don't do it with one device. Do the run through on one device like a laptop, and then plan to use an iPad or a different laptop to conduct the proceeding, and find out that it doesn't work as well as it did during the run through. But I think all of these things, the underlying principle is really just preparation, and try to the best you can anticipate any issues and work them out well in advance, so that these things aren't a distraction, and you can effectively present your case.
Okay. I have one question. I'm going to ask this question. Somebody sent the question. It's probably timing because they sent it earlier. We have moved from this topic, but I think that it probably needs to be addressed. The question was, can the issue of whether an arbitration or mediation is held virtually be dealt with in the applicable contractual clause or via the organizational rules? This would seem to avoid the problem if it comes up.
I would think that may be something that's dealt with on a going forward basis, but I would, I don't think at the time that this issue arose, maybe it was foreseeable, but I don't think it was something that was generally dealt with in arbitration clauses, because people assumed that if you agreed to have an arbitration at a particular place and time, you'd be doing it in person.
But I think it is an issue now in terms of arbitrator availability. So it's not just a question of, are you available on these dates or these months, but are you available for in-person, or are you will you do a virtual hearing? So I think that issue is being played out now. But I think it would be appropriate, ideally, in the future to make its way into institutional rules.
Well, I think it will. I think that it's kind of like the same thing that's happening with the pandemic is impacting the ability to complete contracts. So you have a lot of contracts that are basically being breached, so to speak, because of a pandemic. And some contracts in larger companies, and specifically life sciences, pharmaceutical, they've had, they definitely have it now. They've had a clause in it that says that if it was a pandemic, what happens? I would think that this may be a game changer in terms of how people write contracts going forward, whether it's in person or virtual. And the parties, of course, have to agree to it. But then the aspect of the organizational is different. If the parties put it in the clause saying it has to be in person, I think that would change things. I don't think it would be. Number one, the person who wrote this question was addressing whether you would have a situation where we asked before, who should decide? If it's in the clause, then I don't think nobody else could decide because the party's already decided.
Angie, can I add to that?
Sure.
The questioner was also asking whether it would be possible to take care of this in the institutional rules.
Right.
And I think the answer to that is yes, and yes, it's already happened.
Right.
The fact of the matter is that at least the AAA has taken the position that the rules already provide for an arbitrator to take testimony virtually. And in fact, there is such a rule. And when you posed the polling question earlier about who should decide, the arbitrations, the institution, the court, or otherwise, the AAA's position is that they will not, from an administrative point of view, get involved
Right.
In deciding that issue. And the reason is because the parties have already consented to the use of the AAA rules. Let's just use by illustration the commercial rules. And the commercial rules already address the topic by saying that the arbitrators have the discretion to take testimony virtually. So that's why the administrators will kick this issue to the arbitrators. I remember going back to March, I actually called one of the senior administrators and said, do you have any advice? What are other people doing? You know, what is the best practice? And there was a laugh coming from the other end of the phone saying, good luck, it's all yours. But I think that's an excellent suggestion. I agree with Angie that nobody could have anticipated this pandemic, but people who are writing clauses as we speak would be wise to consider that issue.
Okay, let's get back. Thank you. I forgot who wrote that question. Thank you. Now let's go back to dealing with some of the issues that you guys encountered. Again, to address some of the fears, the witness credibility, security, confidentiality with these large cases that you had. For example, Drew, I think you said to me you had about 40 people or so. I know Mary Ann just did the math and she came to the same thing. What did that look like?
Well, one of the things that we established in our protocol, which was reduced to a procedural order by the tribunal, was who would appear on the screen at any point in time, and so so it was agreed that it would be the three arbitrators, the witness in the event of a witness where witness testimony is being given, and the examining attorney, and everyone else would have their cameras and their microphones off. To avoid any distraction, and then there'd be one designated attorney, representing the witness, who could come on screen to interject an objection or to address any issue that came up during the course of the examination, and that went pretty smoothly. There was, several instances where folks forgot to put their devices on mute, and you get interference and things like that. And then someone does that, and then they walk away, and you hear their kids screaming in the background for 15 minutes while they're doing whatever it is they're doing away from their screen. So those issues do come up, but I think, but certainly there's a limited amount of space on the screen, and so you want to be able to manage that. The other issue is obviously displaying documents. And if you limit the number of faces on the screen while displaying documents, at least certainly on Zoom, you can see in the thumbnail on the side all the three tribunal members plus the witness plus the examining attorney down the right side of your screen while the document that's being shown to the witness is displayed.
Okay, Simon, what about you with your concerns? Because I think you also mentioned that you had 40 plus people at mediation, in a mediation.
Yeah, I just earlier this week, we had a 2-day mediation where we had about 20 people in a Napa hotel with there were three different parties. There was the contractor, the owner, and the subcontractor. And we had about 45 people on Zoom in 5 or 6 different states. We've also settled a $500 million ownership case, and that was 30 people all online across 10 different states. And one of the most important things, and I'm glad Drew brought this up, is when you have, and I'm working on an article about this, because I think this is going to be really the emerging trend, is this quasi in-person, quasi online mediation. And it really requires some sophisticated knowledge, as Drew pointed out, and this was the reoccurring problem throughout, is when someone doesn't mute or someone doesn't silence their speaker, you get this weird feedback. And we had about a 20-minute delay because we couldn't figure out who hadn't muted their thing. And it's very frustrating for those in the mediation when they're doing this big presentation, trying to give an example of what a jury trial would look like and the arguments the parties would want to make. And so I think one of the most important components is, at least for mediation, if you're going to do this quasi in-person and online, is dedicating potentially one laptop for the presenter, and this can also work for arbitration as well for those people online. Don't try to have multiple laptops inside the same room unless you're going to be muted and you maybe have headphones. So think through the logistics and the requirements for what those parties need. But in terms of if you have a mediation online entirely, I recommend it. And I've been doing these online mediations for a long time, at least since Zoom was around in 13 or 2014. And so it was just going to be so much easier if you just encourage the parties, and it's safer for everyone as well to just stay online, and we're going to be able to navigate through this. And again, designating some sort of technical person that can help navigate that as well. But again, I think these breakout features and avoiding this quasi in-person and online, it's going to save you a lot of time. But it's something, Marianne, as well, I just want to reinforce it. Make sure you always do a trial run. Practice, practice, practice. By now, hopefully more people will continue to use Zoom or whatever your dedicated platform is. I think Zoom is superior to all the other ones. But you know, I know if you're working with Geico or the Oregon Supreme Court, you know, they have certain requirements. But I really recommend practice. It will just really save you a lot of time.
Let me ask you a question, because I'm going to kick the question back to the arbitration people. But while you're there, how did you deal with breakout rooms when you have 30 plus people involved?
So for one of the mediations we had, I like to stagger people in, especially if there's going to be no joint session. So for example, I'd ask the plaintiffs to show up at 9 a.m. You can have them all show up in the main room, admit them off the waiting room, and then you just casually admit them in, make sure the entire party's there. You can even lay out the ground rules in that main room and say, okay, I'm going to put you in this breakout room. Now, what is critical, and oftentimes I've noticed mediators and arbitrators alike who are setting up their own Zoom room and go against Richard's good advice and not be the host and have someone else do it, is you forget to press, and this is the most important step, is you go to the lower left-hand corner in the breakout room tab and you go to options and you make sure parties can't voluntarily leave that breakout room.
That's right.
Right? Everyone hopefully knows that. If you just learned it today, it's going to be, this was worth your hour or hour and a half. And so, you know, and then at 9:30, for example, we'll have the defendants come in, and it's really casual. It's really nice. You get to see everyone, make sure everyone's there. And if there's technical issues, you can sort them out as people filter in, and then you put them in the breakout room. And then it's really great. The mediator can have his or her own room, or they can just be in the main room working that out. I think a best practice as well is when you're having so many people is the lead attorney and the mediator, you know, knows that lead attorney is the person who's going to be the MC of sorts. It's not going to be these random people or, you know, clients and other people jumping in. The mediator, what I found is a best practice, always addresses the lead attorney first. And then from there, that lead attorney, lead counsel can determine, okay, we actually want to, you know, Susie needs to say something, John needs to say something now. And it helps to have a much more organized and civil conversation.
Okay. Rich, how did you deal with breakout rooms for arbitration?
I kicked it to the court reporter, who did a phenomenal job. You know, this is consistent with one of the comments that was made on chat by one of the audience members. An industry has literally grown up in the last 6 months around this issue. And I know that the court reporting services are looking at this as a way of expanding their business to provide people who will run the tech side of the hearings. And often they don't charge more, or it's built into the price of the transcription of the hearing. But I wanted to make a comment, if it's okay, Angie, with that would be consistent with the title of our program, which is Lessons Learned. And there are some things that many of us have picked up and tried to integrate into how we conduct these hearings as we get more experience. And what made me think of this is a comment that Drew made much earlier, and that is that even though the platform offers many advantages and frankly has been very responsive to a lot of the concerns that parties have, there are some disadvantages too, and we have to be aware of them.
Yeah.
And if the parties don't cooperate with each other, it will go sideways. It's very, very important that the parties are flexible and recognize that their paramount interest is the same, which is to have a hearing that's fair. And I think if they keep that in mind, it will be fair. But there are a couple of really minor or seemingly minor things that I'd like to mention. And that is, if you're scheduling a hearing and you're trying to figure out how many days, which is what all arbitrators struggle with, you know, at the beginning of a case, you're trying to figure out, is it a week case? Is it 2 weeks? Is it 3 days? Is it 5 days? And whatever you decide, add a day or two if it's going to be done virtually, because the Zoom fatigue is a real thing. And you need more breaks. It's hard to go through hours at a time. If you're in a conference room in person, you can get up, you can walk around, you can take a 2-minute break here for stretch. You can take bathroom breaks. And yes, you can do that virtually too, but there's more of a tendency for people just to sit and go on and on and on because they're sitting in their living room or they're sitting in their kitchens. And I think the arbitrators have to recognize that there is a downside to that. And it, by and large, I think takes longer unless you want to subject people to headaches and aggravation. So that's one thing I recommend. Another is, I think arbitrators need to be more flexible on the online platform. For example, I had a situation about a week ago where there was an issue that required oral argument by the parties' counsel on an issue of evidence. And the lead lawyer argued, and I peeked over and looked at the second chair, and it looked like the second chair wanted to say something. And you know, normally we don't permit more than one lawyer to articulate on behalf of a party on a single issue. But I said, Ms. So-and-so, did you want to add to that? And she was very grateful for the ability to do that. And what I was thinking to myself is, if we were in a conference room, the second chair would have been able to send a note, you know, just slip a note to the first chair or whisper in his ear. But we can't do that virtually. So why not depart from the norms and just allow some more flexibility? And I think that's also been effective. And lastly, I've been finding that more of my virtual arbitrations have been run on a chess clock basis. I'm not sure why, but it's been working out very well. And I think the reason is because the parties came up with these ideas, and they were worried about people having equal time on online hearings, and it's worked out very well. You know, each party gets 30 hours on the record. You know, they can use that 30 hours any way they wish. So that's another thing to keep in mind.
So, you know, you just segued me into, I see we're kind of coming up to, I think we had agreed that we would go to about 75 minutes. We got about another 10 minutes. So let's kind of talk, if we can, about some of those issues you mentioned in the beginning, using lessons learned. And I'm going to go to Mary Ann. We're going to talk about what lessons that you, I mean, one of the issues that Rich and you talked about before, and as well as Drew, was credibility issues, confidentiality, cybersecurity. What have you learned, if anything? And I guess I should maybe start with Drew when it comes to his client. What did you learn through doing the virtual since we began to now, how to deal with those issues that we talked about in the beginning?
I think, you know, I think it's sort of as I said before, so part of it is foresight, trying to anticipate the issues and then addressing them. I think the big concern is witness coaching, or really witness coaching, and then I think also the ability to judge the credibility of witnesses. The ability to judge the credibility of witnesses is what it is. Either the platform allows for that or it doesn't, or the particular arbitrators who are making those determinations find that the platform lends itself to that or not. I don't think there's anything any of the participants can do to make the ability to judge credibility better in a virtual platform versus in person. Certainly, as lawyers, you can compare our clients to try to prepare to present virtually, the things to do to look into the camera, and sort of the equivalent of what you tell them if they're talking to an arbitrator or if they're in court and talking to a jury, to, take your time, turn around, answer, direct your question towards the arbitrator, things like that. Well, virtually, it's more about staying focused and looking forward. But in terms of guarding against the type of I guess improper witness influence that's been going on, I think it's the things we've talked about, having the protocol in place to make sure, have a 360. You can ask. We didn't in our case, I think, but some other cases might lend itself to this. Require that the witness show a 360 panoramic view of the room they're in before their testimony starts, and perhaps periodically throughout. Maybe you can ask them to demonstrate on the screen that their phone is off. Certainly with the exhibits, as I think we discussed, several of us have had the experience where you send them in a sealed package and require them to be open at a particular point in time. At some point, for example, if you have a witness whose testimony carries over, it's very much as it is in person, sort of on your honor system, that they're not going to talk to anyone overnight, and that they're not going to go back and be viewing exhibits that they might otherwise leave in the hearing room. I think if you're concerned about that, if you know that a witness's testimony is going to go over, carry over to a second day, that the second day, the documents you want to get to at the end of which documents you want to get to at the end of the examination, you want to make sure the witness doesn't have them. Send them in 2 boxes, and instruct that the witness open the first box only, and not open the second box until asked. That's one way to deal with that. So, and all those things I think depend on, the rapport between the parties, who the witness is, the degree of trust, and all those things I think are variable and change depending on the specific situations. But I think in order to deal with all those, you have to foresee those issues and address them ahead of time.
Okay. I'm sorry. I think the timing of some of the questions comes in a little late. This is back to Rich. I'm sorry. Here, somebody asked, Steve Skullick said, who runs the chess clock, the tribunal chair or someone else?
Not the tribunal chair. The way that I've been doing it is to have the court reporter be the official scorer, and to provide the tribunal chair and the parties with periodic updates as to how much time each have used. In large cases, I've also asked each side to designate one member of their team to kind of double check and have the lawyers on both sides kind of confer and see how much they agree with what the court reporter has down. Usually they're within 3 or 4 or 5 minutes of each other, so it doesn't become an issue.
All right, so Rich, you started. Mary Ann, lessons learned. What lessons did you learn in terms, I know you mentioned earlier a lot of different things that you saw about preparing, but when it comes to some of these things we talked about before, the credibility, did you have any issues, Mary Ann, with wondering about witness credibility or whether witnesses were being coached in your matters?
On credibility, I had no issues whatsoever. I mean, the witness was, easily visible, maybe even more visible in terms of a close-up of their face. So their facial expressions and body language were easy to read. And so much of credibility is kind of the rapport and how they answer the questions and whether they're being evasive. So credibility to me was just not an issue. And I would wonder if you were doing an in-person hearing these days with masks and social distancing, if you would actually have more difficulty with respect to credibility. And some of these other issues, before I swore the witness in with each witness, I would go through a litany of questions, starting with, you know, are you in the room alone? Do you anticipate continuing to be alone? If anybody walks in the room, it's your responsibility to identify them to us. And I think it's kind of like having a fence. You know, if there's a fence, then you don't tend to go across it. But so laying it out ahead of time, I think is really useful. Along the same lines, I made it clear that there would to be no recording of the proceedings by any of the witnesses, and that I reminded the witnesses that just as if they were in a regular hearing room, that they were not to talk to counsel while they were still, you know, giving testimony. And the last thing I said to them, and I think this was really important, although very, you know, minor in some ways too, was we had Veritex running the hearing, and I think they do a lot of, I think prior to COVID, did a lot of setups in courtrooms of monitors and whatnot. And they had a tech expert, and we had a cell phone for the tech expert, and if anybody got in trouble, they were to call the tech expert, and then we could kind of see where we were. And so I'd ask at the end of this litany, do you have the tech expert's number? And inevitably they would say somewhere here, because at some point in time it had been emailed to them, but they didn't have it right in front of them. So they all got it right in front of them. So nobody had, if anything happened, and there was only one occasion in which we had to, you know, somebody had an issue and they lost some side of a document, and they called the tech expert and it was resolved pretty readily.
Okay. All right, let's, as we try to wrap down here, let's talk about this last issue that I think the panel had decided would be interesting, which would be the future. We kind of talked a little bit about before, the future of in-person versus virtual hearing post-COVID. And so I'm gonna try to let each one of you kind of give me a sense in terms of preliminary hearings, motions, hybrids, alternatives, requirements, guidelines. Let's kind of walk through that a little bit of what each of you think is going to happen. I mean, it's kind of looking in that crystal ball, but as we speak now, it doesn't look like we're going to be totally in person as we used to know it in 2020. So Marianne, you're still there. What do you see in your crystal ball with the future of in-person versus virtual post COVID?
I think it'll be a real alternative post-COVID as people become more and more familiar with the platform. And as Simon says, as the platform evolves and becomes more sophisticated. So I see that being, you know, how do you want to do this? Do you want to be in person or do you want to be virtual? I also see it being, you know, possibilities for a hybrid. I think the days are over when you bring in a witness from Japan or somewhere to give an hour's worth of testimony. So I certainly think that, you know, it'll be definitely hybrid, but I could see people just making a reasoned choice in terms of costs and in terms of, you know, efficiency and what makes sense given what the facts and what the case is.
Okay, let me ask you this, because somebody just asked, and actually this was from Les from Silicon Valley, and the question was, do you see any lessons learned in international versus domestic matters from a virtual world perspective?
In my view, it makes even more sense. I mean, you have the time difference you have to deal with, but in terms of cost savings and travel and whatnot, I think it makes enormous amount of sense. I think, you know, you have to, obviously, it's seated where it's seated, and so there has to be an agreement, you know, where is a virtual hearing, what's the seat of the virtual hearing, and where is it taking place? So, you know, ideally there'd be some agreement with respect to that.
Okay, all right, Drew, I'm going to switch to you, and then I'll go to Rich and leave Simon as a wrap up. Drew, from a client perspective, advocate perspective rather, what lessons do you think have been learned, and how do you see the future. I'm sorry, I forget that lessons learned. want you to answer the same question about international
Sure.
versus domestic from an advocate perspective that Les put out. But I also want you to, after that answer, would you see the future post-COVID?
Sure. I think the two might be somewhat related. I think one of the positives to come out of the situation we've all found ourselves in, and sort of being forced to go to the virtual platform and become comfortable with the technology that's out there. And I think, as Simon mentioned, certainly the technology will only get better and more user-friendly and offer more options. Is that I think the virtual platform is a real option at every stage in the proceedings. And I think the days of having people travel halfway across the world for organizational meetings is probably over. They may do that for, a high stakes, multi-day or multi-week evidentiary hearing. I don't think that the virtual platform is going to totally replace in-person hearings, because I do still think at bottom the in-person hearing is a better forum. But certainly for things like hearings on preliminary matters or preliminary hearings, or even single issue motions like jurisdictional objections and things like that, I think that this is a real cost-effective and time-efficient alternative. And just think of, when people have to travel, scheduling becomes a real issue, because a hearing, on a particular issue that might take 2 or 3 hours actually requires a 3-day block of time for everyone who has to travel for it. And now it can potentially require a 3-hour block of time. You log on at the outset of the hearing, and you log off at the end of the hearing. You don't have to catch a flight or a train, and it's a lot more cost effective. And I think in the international context, that's even more so. I think I've been involved, and I'm sure others have too, in cases where you have parties and arbitrators that represent or come from 2, 3, 4, 6 different countries, and it's a problem to coordinate that, to get all those people to travel to one place for any purpose. And so I also think, to the extent that you have lower stakes disputes that aren't necessarily critical, that the parties need to resolve, but it's not that critical for them, I don't think that there's any concerns with not being in person. I think that the virtual platform will remain for resolving, for evidentiary hearings as well.
Rich?
I agree with that. I mean, I'm asked frequently, what do you think is going to happen when the pandemic is over? And my view is, well, there is now another very viable option with regard to hearings. And I don't think it's going to replace in-person hearings. I think people are itching to go back to being in conference rooms and so on. But I think all the factors that have been mentioned in terms of time, cost, travel are going to be relevant in determining at the outset of each case, well, should we do this in person or should we do it virtually? And given the fact that all of the changes that have been made to the platform, ever increasing the security and augmenting the convenience, is going to make virtual hearings a solid option going forward. I completely agree with Drew. I think the landscape with regard to preliminary hearings, oral arguments of dispositive motions and discovery motions, panel deliberations, I think that's all going to stay on Zoom or a virtual platform. There's no reason for people to get in the same room together for that kind of thing, given the cost of travel alone. But there's one other comment that I'd like to make, which I think is going to be a lasting effect of the virtual platform. And that is the self-determination of arbitration, which is a lot of the reason why people choose arbitration as a forum, has now been enhanced even further. And what I mean by that is that one of the reasons that people select arbitration as a dispute resolution mechanism is they get to pick the fact finder. You don't, your case is not dependent upon the role of a wheel and where it stops and what judge you draw. You can look at a list and you can select arbitrators off that list. Well, now just think about the list. The list is no longer going to be centric to the hearing locale. If the hearing locale is Wilmington, Delaware, traditionally the lists of arbitrators that are presented by the provider are going to be 10, 12, 15, 20 people in the Mid-Atlantic region. Well, think about it. Now you can select arbitrators from anywhere if you're going to have a virtual hearing, and it doesn't change the equation at all for the arbitrators in terms of cost or travel. So I think that's going to open up opportunities. It's also going to expand the opportunities for diverse arbitrators, in my view, because they will become available to a nationwide customer base, so to speak, rather than depending upon the diversity of a particular region of the country. So I think that's going to be one of the lasting effects.
Okay. Simon.
Yeah, I couldn't agree more with the panel. We haven't reached the bottom of this economic recession. In-house budgets will be slashed. Law firms will have to find areas to cut. The loads of courthouses. By pushing off those courthouses that decided not to use Zoom or couldn't use Zoom or other platforms, our work will become more important than ever before. I want to talk about the technology side. I mean, in online dispute resolution, the first and the second party are, side one, side two, plaintiffs, defendants. The third party obviously is Richard or Drew or Marianne, Angie. But the fourth party is technology, right? And we introduce it into our practice since the beginning of COVID, or for those who were online before. So Zoom is the fourth party. But Zoom is not going to be the only thing around. I work for Legaler, which we're developing a platform that has that will eventually have tools where you can collect payment instantly, where you can have document automation. But I would keep an eye out for how this technology is going to evolve even more. For example, case evaluation, ZOPA, zone of a potential agreement. Even enforcement of arbitration rulings as well. Automated negotiation, document drafting. A lot of these tools are going to become handy for you. And so keep an eye out, but also have a skeptical eye. Make sure you know that it is safe and that you're, you've consulted with experts in the field and that you stay aware of this. And so to me, I'm betting big on dispute resolution. There's going to be even more disputes as the world continues, and hopefully for those that have made the switch online, it will continue to serve as a competitive advantage for your own practice, and that clients are even more satisfied by saving money and still getting the high quality third party that neutral that retained you. So I'm really excited about the future, and the technology will only get better and more secure.
Okay, so now I'm going to wrap up one round. Last question for everybody that's no more than 30 seconds, and the word is best practices. And the second word is virtual hearings or virtual mediations. What does that mean to you, Simon?
I'm going to sound like a broken record, but best practice to me is practicing. It's providing clients an opportunity to practice beforehand, to giving them a 1-pager or 2-pager on what to expect when it's online, and being able to improvise when something goes wrong, understanding the technology enough to say, I'm just going to close the meeting, we'll start over, or I'm going to close all the breakout rooms, bring everyone together, whatever it may be. But just as we are all masters of bringing people together or understanding the case, become your own master of understanding the fourth party, the technology you bring into your sessions and hearings.
Drew?
I think it's just foresight and cooperation, as I mentioned before. I think you have to identify the issues, and then you have to work to cooperate to address them.
Rich?
To me, the watchword would be fairness, because when I think about arbitration, I think about the hallmarks, which are expedition, inexpensive, and fair. And we know that virtual hearings can take care of the first two. And the challenge is on the fairness. And I think that means, in terms of best practices, making sure that you give everybody an opportunity to weigh in about what their concerns are about the virtual hearing, address those, document them, and then do all of the things that have been recommended by the panelists to make sure it goes smoothly in terms of making sure you've got somebody who knows what they're doing to run it, do tests, and be prepared to be flexible during the course of the hearing.
Mary Ann.
Goal, and I apologize for all the sunlight because as you know, I've lost power here. But the goal is to make the online experience as much as possible like an in-person hearing. And that brings me back to what Simon said, because if you practice and you do these run-throughs, then you can see where your issues might be. You can anticipate what you need to do and what you need to change so that you don't run into these, you know, glitches, and you don't have people who are fearful of going forward because of what might happen. So I think practice is huge. I think anticipation of, you know, how this can be the most like an in-person hearing, and trying to fairly move the parties along in that direction.
Alrighty. Okay, I want to thank the panel. Thank you, Rich, Mary Ann, Simon, and Drew. And I also want to thank our co-sponsors, our sponsor, Silicon Valley Arbitration Mediation Center, as well as the College of Commercial Arbitrators and Shafik Lindsay LLP. I hope everybody enjoyed this, and I appreciate the questions that came forward. Thank you.
Thank you.
Thank you, Anthony.
Thanks, Angie.
Angie.